No, you should be okay. You don't need the podium, or you want to just sit
No,
down?
no, that's
Okay, that's fine. No, no, it's fine. Inshallah. بسم الله الرحمن الرحيم الحمد لله الحمد لله وكفى وسلام على عباده الذين اصطفى ما بعد. Honorable elders, respected brothers, sisters, dear children in Islam, Assalamu alaikum wa rahmatullahi wa barakatuh. On behalf of Darul Khair Center in Stowe, I'd like to welcome all of you for this very, very important program regarding wills and inheritance. And we are very pleased to have with us, alhamdulillah, today Brother Shahzad Siddiqui. And after, inshallah, Brother Shahzad Siddiqui, we have another guest as well. He will be, inshallah, introducing Muslim Care funeral services. Inshallah, Brother Shahid Naqi will come to the front afterwards and also explain the program for affordable funeral services, inshallah. So we'll begin, inshallah, by an introduction by myself, and then I'll pass over the mic to Brother Shahzad, inshallah. So as you know, Allah subhanahu wa ta'ala, we are so fortunate that we belong to the Ummah of Muhammad sallallahu alayhi wasallam, and Allah subhanahu wa ta'ala has chosen us for us deen of His, the deen of Islam. Allah subhanahu wa ta'ala, and this deen is complete. Allah mentions, Al-yawma akmaltu lakum deenakum wa atmamtu alaykum ni'mati wa raditu lakum al-Islam deena. That Allah, in the farewell sermon, on the farewell Hajj, and just before 80 days or so before the demise of Rasulullah sallallahu alayhi wasallam, this ayah was revealed, that today I've completed for you and perfected you for my deen upon you, and this deen of Islam. وَرَضِيتُ لَكُمُ الْإِسْلَامَ دِينًا. I have chosen for you this deen of Islam. And as we know, the deen of Islam just not refer to just our spiritual ibadat, like prayers and siyam, etc., but it also deals with our day-to-day dealings, and everything else encompasses our whole way of life. And even to the extent of how we use the bathroom. Salman al-Farsi radiyallahu anhu, once a person made a sarcastic remark, كيف نبيكم يعلمكم كل شيء حتى القراءة. That what sort of a prophet came to you that he taught you each and everything, even to the extent of using the bathroom. So Salman al-Farsi radiyallahu anhu did not shy away from that, but he was very proud, and he said, and he continued to say, yes, that the Prophet did teach us how to use the bathroom. And he went on to explain the method that the Prophet ﷺ taught us how to use the bathroom, that we go in with the left foot and we use for istinja we do it this way and we come out this way. So everything he explained in detail, subhanallah. So this is a whole complete way of life, and it deals with all aspects of life, even to the extent, as I mentioned, with our money, with our finance, where we earn from, how we spend, and where we invest. Nowadays people are very interested in how to invest money. You cannot just invest anywhere and everywhere, but there are certain guidelines and rules. When we want to earn money, we can't just go into any transaction, but there are certain transactions which are halal and other transactions which are considered impermissible and haram. For example, ribawi and interest-based transactions. So similarly, Allah subhanahu wa ta'ala has also taught us that after we go from this world, then what happens with our wealth? Remember, in one hadith, the Prophet ﷺ says that, Ibn Adam says, Mali, Mali, my wealth, my wealth. The Prophet ﷺ said, your wealth is that which you have eaten and digested, or which you have worn and thrown away, and whatever you have sent for the hereafter. Because once you go from this world, that no longer is your wealth. That wealth now belongs to your heirs. And so, subhanallah, even when we go from this world, how is that wealth to be distributed amongst the heirs? That is also mentioned, and we know in detail in Surah An-Nisa. And Allah subhanahu wa ta'ala says this is ordained, faridatun min Allah. It has already been ordered and already been determined by Allah subhanahu wa ta'ala. A person cannot say, okay, you know what, that when I die, I'm going to give this much to this much. And nowadays, ridiculous things happen. And inshallah, Brother Shahzad Siddiqui will go into more detail about this. People leave millions of dollars to their dogs or to their kittens or to some other place and leave nothing to their heirs. And Islam has come at a time when, in the time of Jahiliyyah, subhanallah, only the strongest, they used to get everything. Once, the complaint came from a woman whose husband was martyred, and she had two daughters and herself. And the brothers came and took everything and left nothing for her. So she came and complained to the Prophet ﷺ and said, Ya Rasulullah, that look, they took everything, nothing is left behind for me and my daughters. And Allah subhanahu wa ta'ala revealed the ayah, He says, لِلْرِجَالِ نَصِيبٌ مِمَّا تَرَكَ الْوَالِدَانِ وَالْأَقْرَبُونَ and وَلِلْرِجَالِ نَصِيبٌ مِمَّا. So the men have a portion, but even the women have a portion. And then we have Yusikumullah, which is one of the most difficult verses in the Quran that for the Huffaz to memorize. So that those verses were revealed to show and to indicate that who receives what after our demise. And if we follow that, alhamdulillah, nowadays people don't want to follow, they want to follow their own desires and what they want, especially when it comes to estate and money. And then if we don't follow what Allah and His Messenger ﷺ have taught us and left behind, then there's going to be disputes. There's going to be arguments. And instead of, when we go from this world, all our a'mal stop. إِنْ قَطَعَ عَمَلُ ابْنَ آدَمَ إِلَّا مِنْ ثَلَاثٍ. All our actions stop except for three. And one of them is waladun salihun yad'u lahu. You leave behind pious children who are going to actually make dua for you. But if you have not left a will, and if you have not instructed that this inheritance of the wealth left behind will be distributed in accordance with the Quran and Sunnah, and you yourself have muddled things up before you left this world, then what's going to happen? Instead of those people making dua for you, Allah forbid, they're going to be cursing you, because they're going to be quarreling and fighting over the money that you left. So it's very, very important that this is a science, a topic that needs to be discussed and it needs to be detailed. And when somebody passes away, then we write to the muftis that this is a situation, these many people have been left behind, and so on and so forth. But before we get to that, I just want to mention the procedure, inshallah, of when a person passes away, what normally should we do with the estate and the inheritance. First and foremost, we are taught that when a person passes away, if the person has debt, his debts need to be repaid. The Prophet ﷺ was very strict on that. Once he came and a Sahabi had not paid the debts, and the Prophet ﷺ did not do his Salatul Janazah. Said no, once his debts are taken. So one Sahabi said, Ya Rasul, I'll take care of his debts. Then the Prophet ﷺ returned and did his Salatul Janazah. So we have to make sure that when we die, we allocate our money or give the wasiyah to our children that I have this much debt left. And normally when you attend a Salatul Janazah, that time people normally announce that, look, when we go, if there's any money owing, then go and meet with the sons and so on, so that you can claim the money, whatever debt you had with this person. So number one, debt has to be repaid. Then afterwards we go to the janazah. The janazah nowadays is getting more and more expensive, but the janazah expenses need to be taken care of. That's where inshallah brother Shahid Naqi at the end will explain of the membership program that is there for affordability, because nowadays the janazah, the plots are getting more and more expensive. There are some places in the GTA now where one plot is $12,000, $15,000. If you go in where my grandmother is buried in near Young and Shepherd, if you go there now, it's $15,000 to $12,000 to $15,000. So it's becoming more and more expensive and challenging. After that is done, then the wasiyah and the bequest can be made by the person who passes away from 1/3 of his wealth. So 1/3 of his wealth, he can say, okay, when I die, from 1/3 of the wealth, after the debt has been paid, after the janazah expenses have been done, then whatever money is left over from there, 1/3 of it, I want to give to the masjid, or I want to give to the orphanage, or I want to give to the hospital. Whatever, that 1/3 has to be given. Thereafter, what is remaining from the 2/3, that will be distributed according to the Quran and Sunnah. And inshallah, if we abide by these rules and regulations, And there's also a hadith of the Prophet ﷺ, according to Abdullah ibn Umar radiallahu anhu, that a person 2 days should not go by except a will should be written, his wasiyah should be written. And other common mistakes that we make is in our lifetime we say, you know what, I've given this to, but you haven't really given it to. Hadiyah means when you want to give somebody, if you have several children and one child is your favorite or he's done more for you than the others, you can't just say, okay, after I die, he gets more. No, we don't have the right to do that. Because as I said, when we die, it doesn't belong to us. Allah has already ordained, has already mentioned that what goes to who. So if we want to give, and according to one hadith, the Prophet ﷺ said, in your lifetime, if you want to gift your children, then you should do it equally, so that one is not unfair to the other and there's no argument. Otherwise they say, well, he got so much money and how come I didn't get any? So we should distribute it equally in our lifetime if we have to, if we want to. And gifting means that if you have, for example, a house, you can't just say, I gift it to you and you continue staying there. You have to write over, you have to go to Brother Shahzad and say, okay, I'm transferring my house here to this son or this daughter, or I'm transferring, or you give them 100,000 and deposit it in their accounts. This is the meaning of gifting. This normally when we misunderstand and we say, well, after I die, this person gets this person gets this, and then disputes occur. So you have to actually do tamlik and give ownership. That's different. The hadiyah is different from the wiratha. And so these are some common mistakes that we make, and many more that I don't want to go into right now, inshallah, but I'd rather hand over the mic and inshallah pass it over to Brother Shahzad, who will get into the legal aspects of it, as well as how Islamically it can be implemented in this country as well, and how the will should be written and so on and so forth. Brother Shahzad, mashallah, is very experienced in this. He's done many seminars of this nature in other institutions, and subhanallah, he's a member of our community. I said, well, you should be first here, and we need this as much as any other community. So alhamdulillah, we're so grateful that he's here. And he's also authored, I think, a couple of books, 2 books, 3 books, mashallah, on this topic as well. So inshallah, without further ado, I would like to hand over the mic to Brother Shahzad, inshallah, and take it from here. Jazakumullah khair.
Jazakallah khair. Assalamu alaikum wa rahmatullahi wa barakatuh. Imam, thank you very much, first of all, for the invitation. I think the last time we did this was at Darul Iman many years ago.
Yes, that's right.
And I'm honored now to be in the same community that you're leading the congregation. May Allah give blessings to this and the greater project, inshallah. Thank you also for attending this seminar on a late Friday evening to discuss the sacred law. I see some familiar faces, some of whom I've served on long and sensitive matters, and others of whom I've traveled, for example, to Umrah, shared a taxi into the holy city of Makkah, the Haram. Not this Ramadan that just passed, but the one before then. I wanted to begin with the hadith of our Holy Prophet, peace be upon him, who said, learn estate division, and teach it to the people. Because I am someone who will be taken from you, and this knowledge will be taken from you, until there comes a day where 2 men will dispute about the obligatory share, and there'll be no one to judge between them. So obviously this is a very important topic to all Muslims. I wanted to, after reference to the Holy Prophet, also begin with a photograph of a non-Muslim. This is the office of Albert Einstein on the day he passed away at the Institute of Advanced Studies.
Sorry, it's not clear. You have to hold it up.
Okay.
So the sisters can hear.
Okay, so this is a photograph of Albert Einstein's office, the Institute of Advanced Studies in Princeton, on the day that he passed away. So most people were at the funeral in New Jersey. There was one very intelligent photographer from Life magazine who decided to visit Einstein's office and took a picture of it. This is another view of the same office. So I share this with you because I want you to think about the legacy that you leave behind when you leave this world, especially given the events in the Holy Land recently. Einstein said that his greatest regret in life was being involved in the Manhattan Project, which was the project to develop the atomic bomb. He had an interesting relationship with God. I think he said that God does not play dice, which is another reference for Qadar Allah. I'm interested in his life. I'm reading a biography right now of his by Walter Isaacson. But I take my theology from Imam Arif Desai and other sheikhs. So with that in mind, I just want to go through the agenda for today, which is I'm going to discuss wills, obviously, and I'm going to discuss what's an estate, because that's a very important consideration in developing a will. I'm going to discuss what goes into a conventional will, and then I'll end with how you develop a Sharia-compliant will. So first of all, a will is a written document. In the Islamic tradition, it can be an oral testification that you tell two witnesses. There are passages in the Holy Quran that talk about the witnesses not changing what the testification was, and the severe consequences for doing that. But we live in Ontario, non-Muslim jurisdiction, obviously, and therefore a will has to be written here. It affects your wishes after your passage into the next life, and therefore it differs from a power of attorney. There's two general types of power of attorney. The first is a power of attorney for personal care, and that's on medical decisions. There is a scheme in the law called the Healthcare Consent Act. So generally speaking, even if you didn't have that power of attorney, your wife would have, or your husband would have the first rights to make decisions on your behalf in consultation with medical doctors. But that is, can be contentious, and so it's better to put something in a power of attorney for personal care. There's also a power of attorney for property, and that can be limited. It could be, the most common use of it when it's limited is for a property overseas that people are dealing with, and they need to get somebody to do the work to sell that property or otherwise deal with it. But it can also be general. I mean, the sample that we use in the office is quite long and detailed, and it basically covers all kinds of property. So a power of attorney is no good after somebody passes away. Only a will comes into effect at that time, or even a trust document, which is a document you develop in your lifetime, and it also applies to after you pass away. So there are three main categories that a will deals with. The first is what they call an executor or an estate trustee. The second is guardianship for children under the age of 18. And then the third, and obviously very important aspect, is asset distribution in the will. This is a cartoon of a gentleman in the New Yorker saying to his lawyer, "Now read me the part again where I disinherit everybody." I wouldn't recommend you do that as a Muslim. It might have some consequences for you in the Akhirah. But certainly within Ontario, somebody's entitled to do that, to give everything to a charity in their will, to give, as the Imam says, to their dogs or their kittens. There is testamentary freedom here with some limitation. So if you leave very young children, for example, and you give everything to a charity instead of them, then they can challenge the will. Similarly, if you disinherit your wife or your husband on, within the Islamic context, you cannot do so. Obviously, you cannot divorce a wife on your deathbed under Islamic principles, but your wife may be able to challenge the will under the Family Law Act, and vice versa. The husband may be able to do so as well. With regard to testamentary freedom, I wanted to give you the example of a fellow lawyer called Charles Vance Miller. This is a sample of his will that he wrote. It's an interesting document. It generated several books. It generated a movie called The Great Stork Derby. And I'm just going to read from passages of that will, so you get a sense of how much freedom you have in Ontario. So Miller wrote, this will is necessarily uncommon and capricious because I have no dependents or near relations, and no duty rests upon me to leave any property at my death. And what I do leave is proof of my folly in gathering and retaining more than I required in my lifetime. So he had no beneficiaries, this gentleman. And he left us a very significant estate in the Depression era. In his will, he gave $25,000 worth of Ontario Jockey Club stock to 3 staunch enemies of horse racing. He gave $700,000 worth of brewery stock to 7 Methodist ministers to see whether they were more interested in their money or their principles. He gave a joint tenancy in his Jamaican vacation home to 3 lawyers he knew to be sworn enemies. But his most controversial bequest was that the residue of the estate, it's written on this page, was to go to the mother of the highest number of children born in Toronto from the time of his death to the end of the decade. So the wording in the will, was very legal, but essentially he set up this contest where the woman with the most number of children would get $500,000 by the end of 10 years. So there were 4 women at one point with 10 children, and there was one lady with 9 who was hoping for twins before the contest ended. So the Ontario government didn't really like what was going on with this will, and so they challenged the will and said it's null and void. And it went to court, eventually made its way all the way to the Supreme Court of Canada, who said the following: it is the duty of the courts to give effect to contracts and testamentary dispositions according to the settled rules and principles of law, since we are under a reign of law. But there are cases in which rules of law cannot have their normal operation because the law itself recognizes some paramount consideration of public policy which overrides the interest and what otherwise would be the rights and powers of the individual. And then the Supreme Court decided that this will was okay. And so, some lucky ladies shared this prize money. There's another famous case that went to the Ontario Court of Appeal. That was a reverend called Rector Spence. He had a close relationship with 2 daughters of his, one of whom lived in England and one who was local in Canada. And he had a better relationship with the one in Canada. But he was from Jamaica, and she married a Caucasian man, and he disinherited her in the will without mentioning the reason why. So that daughter ended up taking the father's estate to court, and at the first level of court, there was a judge called Madam Justice Corey Gilmore, who I deal with a fair bit. She ruled that this will was discriminatory and therefore was null and void. The estate appealed to the Court of Appeal, and the Court of Appeal reversed that decision and said, no, there's testamentary freedom in Ontario, and you can discriminate. And so therefore, if there's a Muslim will writer, testator, or the testatrix, they can actually discriminate against a non-Muslim in their will if they so desire. There are more strict rules when it comes to charitable trusts, and so if anybody's setting up a waqf and they want to limit the beneficiaries of that, then certainly I'd recommend speaking to a lawyer before you did that. I wanted to talk briefly about what happens if somebody passes away without a will. It's called passing away intestate. And certainly when I began my career in 2007, there was a myth amongst the public that if you didn't have a will, that the government would take your estate. And yet people still didn't write their will with that, widespread belief. So thankfully it's not true. What the government does instead is they follow the Succession Law Reform Act of Ontario. That gives the spouse the first 350,000 of the estate. It's called a preferential share. Then if you have more than 350,000, you share that between the spouse and the children, everything over and above 350,000. If you have no spouse and you have no children, sometimes known as issue, then it goes to your parents. If there's no spouse, no issue, and no children, anybody want to guess where it goes next? Government? No, not yet, thankfully. Brothers and sisters, yeah. And then nieces and nephews. So the government is going to look, very long and hard in terms of, who you have in your family to try and give to beneficiaries. If they can't find anybody, then it escheats to the crown, they call it, goes to now, I suppose, His Majesty. And so you probably don't want that to happen to your estate, especially if you have a small family. So I'd recommend that if you do a will, you have a residuary clause where you gift it to a charity if there's nobody in the family, like there's no beneficiaries under Sharia or the Succession Law Reform Act. You have a clause that grants it to them. So the question naturally becomes, if the government already had a scheme, then why does one even need a will? Obviously, for the Muslim population, the scheme that the government has designed is not in compliance with a lot of religious mandates. There may be competing claims on the estate trustee, otherwise known as the executor. And there might be battles about who gets appointed as the estate trustee if you don't have it written in a will. And then, you could have competing battles about guardianship as well. Somebody may be appointed that you wouldn't have been happy with if they were appointed to take care of the children. And there's often a division. The executor could be somebody who's financially capable, and then the guardian can be somebody who's good at child rearing. So those two roles are somewhat different, and the same person might get appointed to do both roles. Also, without a will, you can't do any estate planning, estate or tax planning. And so I wanted to give you an example from a gentleman called Philip Granovsky. He developed this company called Atlantic Packaging Company. You've probably seen their trucks in the city of Toronto. So he started that company from this office, and he built it into a $25 million business. He had a very good lawyer who did a primary and a secondary will. So I brought samples, actually. This is my will, because I have a professional corporation. So this is a unsigned version of the will that I have signed. So there's a primary will here, and then there's a secondary will. Can anybody, any businessman or otherwise, figure out why there would be two wills for somebody? I don't know if you can figure out from what I've written there. So in Ontario, there's probate taxes. You have to pay probate taxes on the value of your estate. So an easy example is if you own a house that's paid off, that's $1 million, the probate taxes are approximately $15,000. So what Granovsky did is in the primary will, it dealt with most of his assets except the shares of his private corporation. In the secondary will, it deals with the shares only. So only this will gets probated in the court, only the first one, not the second one. And that means you save on probate taxes. So if you have a private business, you have shares in private corporations, I'd recommend doing a secondary will because you can save significant taxes that way. All right, very important question for all of you is what's in an estate? So there is three main asset categories that we generally deal with in Ontario. The first is real estate. So I'd recommend you go home and you see in your real estate deed what you have written, whether it says joint tenancy or tenants in common. If it's joint tenancy, 100% of that property is going to go to your spouse or whoever else you own the property with. If it's tenants in common, then it's going to be 50-50 between you and your spouse. And so that has implications for your will, because if it's joint tenancy, then the house is not going to come into the will. If it's tenants in common, then your 50% share is going to go according to your will. 50% will stay with your spouse. Your 50% will be distributed according to your will. Then, with respect to the joint bank accounts, the bank accounts that you have, if they're joint, again, by rights of survivorship, they're going to go to your spouse. Unless you've got very clear direction in your bank account to say, no, this is 50-50 or otherwise. With respect to RSPs, if you have a beneficiary designated, that's going to go directly to the beneficiary. It's not going to fall through the will. If you get life insurance through work, again, that's going to go directly to the beneficiary. It's not going to pass through the will. So you may have an Islamic will, but if your assets are already structured jointly, then they're going to pass to the survivor without going through the will. And then the will probably apply to the next generation, being the children, with the sons potentially getting double the share of the daughters. So this is probably the most important part of the presentation to understand, is how you've already structured your affairs will have implications for your estate. So just before I move on, if there's no beneficiary designated, it'll go into your estate. If the beneficiary passes away before you, it'll go into your estate. If the beneficiary is the estate, then obviously it'll go into the estate as well. These are requirements for a conventional will in Ontario. You need to obviously have your name. You have to have an executor appointed. You have to have a guardian if you have children of the age of 18. You have to deal with the asset distribution. You have to sign the will, and you have to have two witnesses who sign with you, one of whom has to sign an affidavit of execution. Otherwise, the will is not valid if it's a typewritten will. Lawyers have to be careful about the circumstances in which they sign a will. I did a case involving a gentleman who had 4th stage brain cancer. The lawyer went to the house. The witness that he brought with him stayed in the car outside. When they signed the will, the name of the testator was wrong. The name of his wife was wrong. The will gave everything to the wife, but then also gave everything divided equally to the two sons. So this ended up becoming a case. I inherited the case, and we had to bring the lawyer into the proceedings, and the office of the children's lawyer got involved. The assets in Pakistan were distributed as per Sharia. but thankfully there was a very good lawyer on the other side, a Jewish lady called Susan Stamm. And then, the lawyer had his own lawyer, and we resolved the case before it actually went into a hearing. But that's just a warning I wouldn't recommend doing a will in rushed circumstances. You can, God forbid, in rushed circumstances, do a will without a lawyer. That's called a holographic will. If you write the whole thing in your hand and sign it, that is a valid will. So this is an example. This was a farmer in Saskatchewan called Cecil Geo Harris. He got stuck under his tractor for several hours and realized that he would probably pass away. So he took out his knife. This is a picture of the knife. He wrote on the tractor tire, "In case I die in this mess, I leave all to the wife." They cut off this piece of the tractor tire and they took it into court, probated it, and the court agreed that it was a valid will. So this is, obviously a very extreme example. May Allah save us from an end like that, but it's proof that these wills are valid in Ontario. But again, I would recommend only doing that in very emergency type situations. Those wills are often challenged. Sometimes there's allegations that they were done under undue influence by one of the beneficiaries. So it's best to do a typewritten will with two witnesses. Doesn't necessarily have to be with a lawyer, but one of the witnesses has to appear before a lawyer and sign an affidavit of execution, as I mentioned earlier. Otherwise, the will is not valid. And the exception is this holographic will. So then the question is, how does one do a Sharia compliant will? And so what I recommend is that rather than saying in your will, things have to be distributed according to Quran and Sunnah, that you spell out the fractions, like in this sample will. This was developed by Manzar Kaf, who's a professor at the Faculty of Islamic Studies in Qatar. He developed the ISNA schedule, which I'll just show you. Like, these are all the inheritance fractions on the majority of the cases that he did. So he did great work. He used to live in America and then he moved to Qatar. But he developed that, and he's also a Sharia scholar on other transactions. So he's done great work for the Ummah, especially in North America. So I'd recommend you do that kind of thing. The Ontario courts are not really interested in getting into debates about Quran and Sunnah. And so if there's a dispute, of one interpretation over another, then the court is going to be very wary about getting involved. They were very wary at one point about enforcing mahar. At one point, you couldn't enforce a mahar in Ontario, which I suppose was good for the divorcing husband. But more and more, the courts have said, well, this is a contract like any other contract. If there's been offer, acceptance, consideration, capacity, we're going to enforce a mahar. But generally, from that body of case law, courts are reluctant to enforce religious type documents. I've been involved in 2 cases at the Supreme Court of Canada. It's a big deal for a lawyer to go up there. Both were on religious freedom, and essentially they involved churches. The first was for the Jehovah's Witnesses, and the second was for the Ethiopian churches. And the court said that it's not our role to get involved in religious issues. We'll leave these to the religious denominations themselves. So then what can go into an Islamic will? So there's a preamble, obviously. The one in my will is on Quran and Sunnah. There are funeral and burial rites that you can put, detailed funeral and burial rites. There's a book I got last time I was at ISNA called Textbook of Muslim Funerals in the West by Amjad Sayyid. This is obviously a very serious book. It reminds me of a joke that Imam Subadar sometimes says to people. One person once asked him, "Do you know Shahzad Siddiqui?" And he said, "Of course I know Shahzad Siddiqui." Every time I think of death, I think of him. So, hopefully I'm remembered for other things as well. But so you can put those provisions in there. I did so much work for the Toronto Muslim Cemetery Corporation that they gifted me 2 plots. So, alhamdulillah, I didn't have to buy those expensive plots over there. The most important part of the Islamic will is the bequests that you put in. Those are to establish waqf. As you know, there's a hadith about what counts for somebody after their passage into the next life. Obviously, one is a pious child that prays for them. And another knowledge that people benefit from. But then the third is sadaqah jariyah. And so it's recommended to at least consider giving something. Within the will, you can't go above the 1/3. I wouldn't even recommend it from an Ontario perspective. There's a hadith that, one of the Sahaba asked the Prophet, peace be upon him, should he give all of his wealth to charity? And the Prophet said, no. Then he said, should I give half of my wealth to charity? Prophet, peace be upon him, said no. Then he said, should I give 1/3? Prophet, peace be upon him, said yes, but even 1/3 is a lot. So, you can put provisions in there with respect to that. You can also give a gift to somebody who wouldn't inherit, like a non-Muslim spouse or an adopted child, or grandchildren who generally wouldn't inherit from a grandparent. It would go to the next generation, being the children. And then you can deal with debt before distribution, and then the asset distribution. From an Islamic perspective, 2/3 is fixed, unless the beneficiaries consent to a different distribution at the time of death. How much time were you planning?
How much more do you need? 5-10 minutes?
5-10 minutes, yeah. So just by way of preamble, I've got a sample here I'd like to read out. My family and friends have been a source of strength and happiness throughout my life, and I request them to honor this by keeping close ties with each other and the relatives and friends of their parents, and ensure that their children do as well. I request that all of my immediate relatives and closest friends, for the sake of Allah and out of fear of Him, to settle their disputes and correct their relationships among themselves, according to the following orders of Allah in the Holy Quran. So fear Allah and amend that which is between you, and obey Allah and His Messenger if you should be believers. That's from Surah Anfal. I remind them that no person dies before their time. The exact duration of each lifespan is precisely determined before we are born by the all-powerful Creator. May He be exalted. Death is tragic only for those who lived out their lives in self-deception, without submitting to the Creator and preparing for the final return to Him. So do not preoccupy yourself with my death, but instead make the proper preparation for your own. And I'll end with what I wrote in the introduction of this book. At the end of the day, the primary objective of the Sharia-compliant will is to ensure the distribution of the estate of the deceased testator or testatrix in a non-Islamic jurisdiction. It is not to mitigate tax liabilities, to shield the assets from legitimate creditors, or to protect the rights of heirs over the rights of others. This is recognized in the Sharia in general, so that a Muslim man on his deathbed cannot disinherit his wife, and one who has greater debts than assets, even in limited liability companies, dies muflis, bankrupt. And it is incumbent upon his beneficiaries to clear up his debts, to protect his reputation in this world and ensure salvation in the next. I'll conclude by saying I think the will may be the only document you can write that can get you into paradise. And that's according to Surah Nisa, verse 13. Do you agree?
Yes, sir.
Inshallah. Jazakallah khair.
Jazakallah Brother Shahzad, inshallah. So I know a lot of us will have questions, inshallah, and shortly we'll take the question and answers with Brother Shahzad, myself, and also before that, I'd like to hand over the mic to Brother Shahid Naqi. Inshallah, as I mentioned, that one of the first things that we have to take care of after a person dies from the inheritance is the janazah and the funeral costs. So, inshallah, Brother Shahid Naqi will give more detail about how it'll be more affordable and more easier for the family once we pass away.
Assalamu alaikum. I just want to introduce an organization that was formed in 2017 by the name of Muslim Care. And the organization was formed basically to help in the ever-increasing cost of the funeral. And obviously it becomes a burden to any family, especially if there's an accident or even otherwise. Unfortunately, nobody is ready for the thing that has to come to everybody, and that is death. So this organization was formed, which is a not-for-profit organization. It is not a charitable organization. So you cannot give any money to it, like a donation. The objective is that the community members, people become members of this organization. There are 2 or 3 requirements. Number 1 is applicable all over the GTA and the surrounding areas. Number 2, you have to be a Canadian resident. And number 3, you've got to be of an eligible age. Now, with these only 3 requirements, a family can be registered for as less an amount as $150. And this is a one-time payment only. At the time of your application, you will give all the particulars of yourself, your spouse, and your children. Children, whether they be 3 or 4 or 5 or 6, whatever God has blessed you with, every child up to the age of 25 can be registered under one family, will be known as one household. So if I have 6 children and me and my wife, we are 8 people, one form giving the names of the dependents and their particulars as required by the form, and the fees is $150. Now, all these 8 people are covered under this plan. God forbid, if the wife dies, the husband, who is the beneficiary, for example, gets a lump sum amount of $6,000 for the funeral costs. Let me take a step back. This organization was formed in 2017, and at that time, $5,000 were fixed as a lump sum payment. Today, we've got over approximately 550 members, and the amount has been increased to $6,000. Now, this increase has also been because of the number of memberships. The more the members become, the more we can give out as a beneficiary amount. Now, coming back to the original question, if somebody, for example, if my wife dies, I get $6,000 being a beneficiary. 4 months later on, I die, my child gets $6,000 for my benefit, for my funeral costs. So every member in that particular form or a household who is registered are covered individually for the amount in case of their death. Now the question comes in, how do we work it out? What is it for? And what do you get out of it? Besides the $6,000, but that will be at your debt or any of the household members' debt. The community basically contributes towards the funeral cost of that member of the community. So besides the $150 that you are only giving one time, afterwards, only when a member dies in a community, the organization informs you that such and such person has passed away, and we will take a maximum of $20 from your bank account on such and such day. Now this $20 is a sadaqah jariyah on your behalf, from your side, as a contribution towards helping a member of the community. So this whole organization and the whole matter can be looked upon from 2 points of view. Number one is to help a fellow member of the community in their hardship, where you do not know under what circumstances that family is going financially. Alhamdulillah, most of the people are well off. They've been blessed with lots of funds and assets by Allah Ta'ala, and therefore they have the option of contributing, in fact, donating the same amount that they get to a masjid or to an orphanage or to anywhere else, and as a sadaqah jariyah themselves. So they're taking it from here and they're giving it as a sadaqah jariyah. So consider it this way. Secondly, the people who are contributing towards the funeral of this particular gentleman or lady or child or whoever is also contributing and earning sadaqah jariyah. So it has both the benefits. It has a benefit that is immediately provided to the family which is affected in their need, in that time of need, when they need help. And people are blessed, but at the same time, people are worried of giving an impression that they need funds, or they need help. Isko sufed poshi kehte hain. To help the people whom you do not know, really. You have not met them, they are just members of the organization, and they pass away, and you are contributing a maximum dollar of $20 only. Only $20 towards the cost of his funeral. You are getting a sadaqah jariyah. Now, in this organization, there is one more benefit. And the objective is to increase the number of members as far as possible. Our immediate plan is, inshallah ta'ala, by 2024, we plan to have approximately 1,000 members. Now, once we have 1,000 members, how much of contribution is going to come in? So we've got two benefits that we can work on. Number one, to meet the increasingly inflationary costs, we can increase the giveaway, the beneficiary amount, from 6,000 to 7,000 to 8,000. Like I said, in 2017, when this organization was formed, the amount was 5,000. Last year, middle of last year, it was increased to 6,000. In the GTA area, we have checked up, an average funeral costs between 7,000 to 8,000 in the outskirts. I'm not talking about GTA, in Toronto especially, that's high, very high. But you have the option for the other graveyards. And an average costs about 6,000 to 8,000, about 7,500 to 8,000 or 8,500. Our objective is to have that many members so that we can say that your complete cost of 7,000 or 8,000 would be met by the organization. That is one objective. The second objective is also that because with the number of members increasing, we can reduce the $20 per funeral contribution that we ask you to only maybe $10, maybe $5. For example, if there are 1,000 members and everybody is contributing at the moment 20, that's 20,000 bucks. We are not dishing out 20,000 bucks. We are just giving 6,000. So what happens to the remaining? So instead of taking that remaining, which we can, because we have signed the document and a commitment is there from you, what we can do is to charge $15, for example, instead of $20. Now there's still a difference. So we can increase the 6,000 to 8,000 and we can reduce the individual contribution from let's say $20 to $15 or $10, so that there is everybody benefits. The beneficiary family also benefits, and also the contribution per funeral contribution from the members is also reduced, so that the pressure on them is also reduced. It's a very simple 2-page form that needs to be filled up. There is no need to give any money upfront. What you are doing is, if you can go to daruliman.org, the website, right in the front of the website will be this form, will be this brochure that I've got. And once you scroll down that particular pamphlet, there's forms to be submitted. You just fill in those forms and you hit the submit button. We will get all the information. We will contact you, and at that time we will require a void check from you, which gets attached to your application. The filled application, after checking, goes to the Muslim Care Organization. There is a waiting period of 2 months, and this is called a cooling off period, where you also think about it. Nobody is forcing you into this, and they also will see in the meantime to check up your particulars and everything else that they're finding. After the period of 2 months is over, you will be informed by email that your registration is complete, and you will be given a registration number. At that time, the $150 will be taken from your account. So even for those 2 month period, the waiting period, you are not a member and you have not paid anything. It is only once your registration is complete and is accepted, then this amount of money will be taken. There's another very good question that is normally people ask, is that my father or my mother live with me. What happens then? Very simple. Anybody above the age of 25 has to file a separate application. Obviously, if I'm 40, 45, 50 years old with my wife and 2 children, I'm obviously above 25, I can file my own application, assuming my children are below 25 or under 25. Then my parents are living with me, or my mother or my father or both. I'll file a separate application for them because they are over 25. But because the address is the same, as long as the address is the same, their fee of $150 will be waived. It will not be charged. Only from one household, from one family, one address, only one amount of $150 will be charged. So this is an added benefit. Then your children, for example, you've got a daughter or you've got a son who's now next year becomes 25 years old. He was registered with you as a family member. Now he's 25. After the age of 25, he's supposed to file his own application and give the reference that he was a member of this particular registration number. And his $150 will also be waived. He will not be charged because he was already a member of the organization. So these are many, many other kind of benefits in any particular circumstances if people have got specific questions or considerations. They can come to us. We can put up, if we do not have an answer immediately, we can take it up with them. We can get an answer to you, for you and everything. Now, if the death occurs in any place in Canada or the USA, the payment is going to be made. Number one. Then the question arose, what if I've gone home to India or Pakistan or for Umrah or for gone on a trip to Honolulu and I die there, what happens? Even then, a death certificate is required and proof of death is required, and on the basis of that, the amount will be disbursed to the people. It's not that we are restricting. There are different organizations which restrict the disbursement of funds, but not this organization. In this organization, wherever your death occurs, and it's very simple. In Canada, you cannot move a dead body from the house or from the hospital until and unless the doctor signs a death certificate. The funeral home people do not pick up the body. So that is the document that we require. And wherever the janaza is happening, in any masjid or wherever, for example, they issue a certificate. That is required. These two documents, submit these two documents, and the amount is given to you by check. Thank you.
Sure. Jazakallah khair, Shahid Bhai, for all that information. Something if we want to look into, inshallah, because of the rise of cost of funeral arrangements now. If anyone has questions quickly for Brother Shahzad, also for Brother Shahid, inshallah, you can meet him on the way out and take some forms if you're interested. So if you have any questions right now regarding the wills and inheritance, you can ask the question. For sisters, if you have any questions, you can write it down and send it over, inshallah. Just knock on the door and a person will, one of the brothers will collect your questions, inshallah. Quickly, we don't have much time. If there's any questions from the brother side, please.
Yeah, I have a question about the debt. So, even in the Holy Quran, and as Maulana mentioned that before the funeral happens, somebody needs to take over the responsibility of the debt. So, considering over here, there's a different type of debts. So, what type of debts we need to worry about at that time? Even same thing going in the bill. That there could be a house, there could be some other business, there could be some other property. Where this debt will go? Like, who is the beneficiary? It will automatically go to them, or the person who died. So, how we handle that?
Okay, so the good news is in Canada, there's no inheritance tax or anything that the beneficiaries inherit from the estate as far as a liability is concerned. Okay? So, for example, there's that probate tax I mentioned. That's usually 1.5% of the value of the asset above 50,000. So 1.5, if the estate is less than 50,000, there's no probate tax. If the estate is above 50,000, then 1.5 starts applying. So the example I gave is if there's a fully paid off house, $1 million, then there's $15,000 worth of probate tax. There are other significant taxes, like if you own not only a principal residence, but investment properties. Those investment properties, there's a capital gains tax that you have to pay on those. There are deemed dispositions of RSPs if they're not going to a beneficiary. So capital gains taxes have to be paid on RSPs. Life insurance doesn't have tax except if it flows through the estate, and then it's subject to the probate tax. All of that tax is for the estate. It's not for the beneficiaries. As a practical matter, like if there's just one illiquid asset like a house and there's no cash in the estate, the beneficiaries are going to have to find a way to pay, the tax. Or, if there's any debt on that property. But they're not legally responsible for it. the estate is legally responsible for it. So if that situation arises, the beneficiaries might have to sell the house in order to pay the tax. But it's not their tax, it's the tax of the deceased.
But who needs to take that responsibility? That was my more question. Because if there is a Sharia requirement, that person has to die debt-free, or somebody has to take the responsibility, there might be a chance person doesn't have a kid or even don't have a wife or something, but he does have a house or some other property. Who will take over that responsibility? That was my question.
So as Brother Shahzad mentioned, legally, when it comes to taxes and all that, then he mentioned it. As for the Sharia point of view, for example, you owe somebody, the person who passes away owes somebody 5,000 or 10,000 or whatever it is. So whatever is the amount, for example, that person has left behind a house and they sell it off, and from there, whatever amount comes to them, they have to make sure that from their 10,000 goes to the beneficiaries, the people who inherit, the heirs will have to take that responsibility to make sure from the inheritance wealth that they would pay it off. If there's nothing left behind, it doesn't come upon the family, but that person will be sinful because he left without giving advice before he passed away that I will so and so money to so and so. So that is why normally we announce that the children take the responsibility, or the siblings or whatever, and they say, we will take the responsibility of paying off that debt, basically.
Yes.
So I have several questions.
Okay. Maybe I should write them down.
I kind of wrote down. So you know how you said when you structure the different types of accounts, joint estate, joint accounts, whatnot, and it goes up outside of the will. So now Islamically, one, how should those types of estates or joint accounts be, dispersed as inheritance? And then how would you include it so that they do get dispersed to the Islamic will?
Did you understand the question?
Like, what's the Sharia perspective on a joint bank account, for example?
Okay. So if it's a joint bank account, then if the husband and wife both are contributing to that bank account, and if they can determine that, okay, the wife has worked so much and the husband has worked so much, and this is in the bank account, so the wife is entitled to her money. For example, if the husband passes away, she's entitled to her money, and the husband's money will then be distributed according to Quran and Sunnah. But if it's difficult to determine because both of them have been putting amount and they have not been calculating every month or whatever, then in the end, it will assume that it's 50-50 because both their names are on that account, basically.
So the way he said that the account take become a right survivorship, right? And it's not gonna go against the will. So if even if you have a will, those accounts will not get dispersed according to the will. So how do you structure it so that you get dispersed according to Islamic?
Oh, I see. Right. So you could write in the will that even though this account is joint, it really belongs to me, right? As opposed to whoever else is joint on that account. Might be a little difficult to do between spouses. Like if you really want to follow the Sharia dictates, then it's better to have individual accounts unless there's a specific need for the joint one. Sometimes it's forced. So there's a Supreme Court of Canada case called Pecor versus Pecor, where there was a parent who held a joint bank account with a child. The child then got the bank account by way of survivorship. So the other beneficiaries, they challenged this. And they said, no, the account was only there for the convenience. Like the child was only on for the convenience of the parent. So the Supreme Court agreed that this might actually be the case because sometimes children get put onto a parent's account just to help pay bills and deal with other conveniences. So there is what they call a rebuttable presumption of resulting trust, meaning the court is going to assume that a joint account between a parent and a child is actually the parent's account, not the child's. The child is only there for convenience purposes. But that's rebuttable, meaning the child can bring evidence to say, well, no, this is actually my account. right? So sometimes this joint bank account situation is forced into separation. I'm actually dealing with this for there's a large Italian family in Niagara Falls, 9 siblings. The father gave one of the bank accounts to one particular daughter. Now that daughter is my client, and her evidence is the father specifically told the bank that this is my account. He's putting it into my name for a specific reason because I took care of him, etc. And the bank employees are going to back up that statement. But had he written in his will, I'm giving this particular bank account to this child for this reason, none of this would have arisen. So sometimes it's forced. Better to clarify in your will, and better, maybe more so, to have separate bank accounts if you're really concerned.
Again, when it comes to debts, first of all, we should avoid debts. Unnecessarily taking debts and maxing out credit cards and all that is not an advisable thing. Secondly, if we know that we have debts and it's a good debt or a bad debt, according to the Sharia or against the Sharia, we should make all means that if we go from this world, we leave behind something that will be paid, or we tell our siblings, our children, that look, when I go, these people need to be paid. Okay, you have to write it down. That's one of the things that you can write in the wasiya. So and so, I owe so and so so much. I owe so and so so much. Write everything down. Remember, when it comes to muamalat, the longest ayah in the Quran is in regards to muamalat, or dealings with one another. So have contracts, have everything written down, and keep it, because you think, oh well, it's okay. I owe this person. You die, you don't know. The family is not going to know. They're going to come to the family. Your father or your husband owes this much money. So write everything down. Keep everything clear. And once a person goes from this world, they have to make arrangements. If by chance they tried their best to pay off and they couldn't, and they go from this world, inshallah, there's hope that Allah subhanahu wa ta'ala will forgive them. But always make that effort to make sure that if you go, you give the wasiyah to your children that I owe this much, make sure you pay it. And again, if he doesn't, then as Brother Shahzad mentioned, it will go according to the legally. They'll pay off, they'll sell the house or whatever money they get from the estate and the bank accounts. From there, first and foremost, after the person does away, first and foremost, the debts will be paid, inshallah. So this is just a little bit more detail to the debt situation.
All right, so there's some questions there from a sister. One, if the house is not fully paid, who pays it off? So I think I addressed this a little bit on the question on the debts. The beneficiaries, they don't have the responsibility to pay it off. It's a liability of the estate. But as a practical matter, if they cannot pay it off and an institution is not renewing, for example, then they have to sell that property or buy it out completely. Question: if we have car payments, same principle applies. Please share contact of lawyer who can help with will according to Islamic laws. I'm conflicted on this question. I would say there are about 3 or 4 of us in the city. Faisal Kuti does it. He's busy, part-time being a professor as well, but he's on Corporate Drive in Scarborough. His father's also an imam, Ahmed Kuti. Ibrahim Daniel, he's all the way out in Milton. He only does wills and estates. But sometimes he's difficult to get a hold of, but he's very knowledgeable in the area because this is all he does. There is Muazzin Qureshi. He is in North York, around North York, Lubavitch Avenue. He does real estate as well and corporate law. And I think I do some of it as well. I'm going to leave some business cards as well at the entrance for people who are interested. Any other
That's one last
recommendations?
How much you charge for a regular bill? No, this is a valid question because people are not asking, but they should ask.
I think, inshallah, we can ask that later on a personal basis, inshallah. Ji.
I have a question for Brother Shahzad.
He should say free.
So you showed the slide, right, where the government takes the fee when there is no beneficiary. You remember the slide which you showed?
Yeah.
So that pertaining to that slide, right? I have an example, right? Like if a person has like $500,000 debt and he passes away, right? He commits a suicide or something, and he has a wife which they have gone through a divorce,
Okay.
and he has $500,000 debt. So what happens? But in his RRSP, self-directed RRSP, he has like $1 million and $500,000 debt. What does the government do? He doesn't have any beneficiary.
Like if he's divorced from that particular person, then that's it. Like she doesn't inherit from an Ontario perspective or a Sharia perspective.
But there is $5 million sitting in his account right now. So what does the government do with that money?
So
You answered that.
they're gonna. Sorry.
You answered that. It's okay.
Yeah, it'll go to the crown. It'll
Yeah.
go. Yeah.
It won't go to the wife.
Right. Maybe we'll have to invalidate the will.
A very
Yeah.
basic thing. The difference between a will and an estate, just like that. Okay. Like everybody's talking about a will.
Yeah.
But you also tell me that I have to write a will. But then there's an estate.
Yeah.
When does my assets would determine whether I have an estate or it is my will also have the same assets which are included in my estate. So what is the difference and how do you?
So the will is the written document that governs the estate.
Okay.
And the estate is the assets that go into a pool of assets that have to be distributed to a beneficiary. So I gave the example that you might have an Islamic will, and 1/4 goes to the wife. But if you structured your affairs so that everything is jointly held, the house is joint, the bank account is joint, RSPs have the wife as the beneficiary, then the Islamic will is not going to apply because there's not going to be any assets in the estate. Everything is already going to go automatically by operation of the law.
But according to the will,
No, according to the law.
according to the law.
According to the will, it'll be 1/4, for example, but it won't apply because there's no assets in the estate. The assets have already passed jointly. So the scholars say, yeah, you should put as much as possible within the estate. But that's a discussion you should have with a scholar and a lawyer. I think there was one final question.
Yeah, so just to clarify what you said about the state, some of my friends they said they made a trust. They put all their assets in that, and then they write a will, and they added their children or grandchildren in that, and then they say that the will execution will take care of this asset. So that trust or estate, is it the same thing, or we need to build a trust?
So there are 3 different types of documents. The one I've talked about the most is the will. Then there's also powers of attorney. Those are for giving somebody authority during your lifetime. They don't apply after somebody passes away. All they can be used for afterwards is evidence that, somebody really trusted this person. And then there's a trust. And a trust is a document that you sign within your lifetime, gifting assets within your lifetime. For example, a common one is the parents are holding the property in trust for their children within their lifetime, but they're the registered legal title holders and the children are the beneficiaries. Most of the time, the parents will put a protective clause to say that we have a lifetime interest in the property so that, a son or daughter-in-law doesn't say, well, we want our share now while you're still living. So they'll put some protection in the trust, right? But the ownership beneficial ownership actually belongs to the children. They're the actual owners, except they're not on title. So those are the differences between those three types of documents.
And we can add the business, house, all the asset in that trust, or?
Yes, you can.
Like car,
Yeah.
everything.
But the government, I was talking to my accountant today, and he said the government is coming down very hard on trusts. You can't have a secret trust anymore. You have to report to CRA that you have a trust, and every year you have to file a T3 tax return. So that's a good question, because I had a discussion today with the accountant about it.
I think, time is up, and there's refreshments there. People need to go as well. So, Brother Shahzad, inshallah, will be leaving some business cards. Mashallah, Brother Shahid Naqi, we thank him as well. He's here. On your way out, if you have any questions for either one of them, please feel free to contact them at any time. Inshallah, we'll conclude with a short dua, inshallah. اللهم لك الحمد كله ولك الشكر كله وإليك يرجع الأمر كله لا نحصي ثناء عليك أنت كما أثنيت على نفسك ربنا آتنا في الدنيا حسنة وفي الآخرة حسنة وقنا عذاب النار ربنا ظلمنا أنفسنا وإن لم تغفر لنا وترحمنا لنكونن من الخاسرين اللهم اغفر لجميع المؤمنين والمؤمنات والمسلمين والمسلمات الأحياء منهم والأموات إنك سميع قريب مجيب الدعوات ربنا تقبل منا إنك أنت السميع العليم وتب علينا يا مولانا إنك أنت التواب الرحيم برحمتك يا أرحم الراحمين. Jazakallah once again for coming. And inshallah, we'll have more of these programs in the future, inshallah. Jazakallah.
Assalamu alaikum.